Wonderful. I am delighted to be here. Again, Michael Roosevelt, Senior Court Service Analyst with the Criminal Justice Services. Well, why are we doing this broadcast, Judicial Council? We think it's important that courts come together from time to time to discuss important and critical issues that relate directly to their work. The Lunchbox series is an attempt to have an ongoing conversation about what we can do to better understand what the research says and what are the best practices when it comes to adult drug courts. We call this Adult Drug Court Lunchbox, but it's for everyone and anyone, for drug courts, non-drug courts, or any other type of collaborative courts. We hope, following this broadcast webinar, you'll have an opportunity to kick off ongoing and continuing discussions among your team members about the drug court adult standards. A note, the viewpoints presented during the series do not reflect that of the National Association of Drug Court Professionals or the Judicial Council. This is simply presented as education for your understanding and opportunity to have a dialogue. I'm delighted to introduce Commissioner Gilbert, Ronald J. Gilbert. He's been running drug courts for 22 years and currently oversees 9 treatment courts, 6 adult courts, a juvenile, mental health, and a veterans court. The University of Laverne College of Law alumnus, Commissioner Gilbert practiced law as a public defender for the San Bernardino County Public Defender's Office for 8 years before being appointed to the San Bernardino Municipal Court in 1993. Then, at that point, it was San Bernardino Superior Court in 1995. Since his appointment, Commissioner Gilbert's assignments have included small claims, unlawful detainers, traffic, and preliminary hearings. Welcome, Commissioner Gilbert.
So let's get rolling here. When we talk about effective drug courts, we're talking about using the best practices that we have for our drug courts. And the first thing that we talk about in best practices is having some sort of advance notice or a handbook outlining exactly what to be expected in drug court. One of the problems is that clients tend to have a perception that drug court is a setup for failure. And so by having an advanced a handbook, a contract, spelling out exactly what behaviors are acceptable and not acceptable, what is required to phase from one phase to the other, what you need to graduate, what things are going to get you sanctioned, what kinds of incentives do we have, how your case is dismissed at the end. All these things are things that need to be done in advance so that your clients know when they come into drug court what's to be expected of them, and there's no guesswork. We've attached a copy of what we use in San Bernardino for our handbooks, and we're always adjusting it because of different situations that come up. But I think it's a very good idea to have some physical document laying out to the clients exactly what drug court looks like. Advance notice and opportunity to be heard kind of collectively together. Under opportunity to be heard, it's important that since the clients are getting this handbook and getting this information, that they also be invested in the ability to explain their consequences or explain what they did. We sanction for behavior. We sanction for bad behavior, for positive UAs, for a lot of different things. And oftentimes the client has a explanation that we need to hear, whether that's through the lawyer or through the client themselves. I personally like the clients to talk and explain because sometimes their failure to test has a legitimate explanation. Sometimes the reason for why they didn't make a group or they missed doing their community service has some legitimacy to it, and I like them to be able to articulate and explain what that is. So you always have to give the clients an opportunity to explain their behavior and explain what they did and why they did it. It may not change your outcome, but at least gives them an opportunity to be heard and allows them that kind of a closure and feeling that they've had their day in court and they've been heard. One of the things of drug court is that we try and treat people fairly the same. Having said that, it's very difficult to treat everybody the same because they all come to us with a little bit different backgrounds. So when we talk about equivalent consequences, what we're really looking at is some consistency. So that if a person in phase 1 tests positive, they're probably going to get a similar type of sanction to somebody else who tests positive in phase 1. Having said that, one thing unique about drug court is everybody's a little unique and their situation may lend itself to some adjustments or modifications of those consequences, but for the most part, they should be the same. In the same phase, for the same conduct, should have very similar consequences or sanctions that are going to be put upon them. It's really important that when we talk to our clients that we don't demean them, we don't put them down. They're hard enough for them to walk into a courtroom knowing that they're probably going to get sanctioned, and that's a big thing for them. So we use a lot more praise than we use sanctions. I personally use about a 3-to-1 approach, but I give them dignity. I want them to see that it's a very big thing that they did by walking into court and by taking the sanction instead of running, which is something they've always done in the past. So you need to praise them and give them something that they can feel is something stronger than their mistake, their use, or their whatever they did. By having them in court and by talking to them in a very positive, reward-oriented type approach instead of a abusive, mean, kind of vindictive. So it's really important the way you talk to the clients, both the lawyers and the judge. The judge being the key is that if you're talking to these clients in a way that comes down on them, they're not going to respond by showing up the next time when you want them to walk in and accept their sanction. Professional demeanor is very important. Talk to them like you would want to talk to some of your colleagues. I think that's a very important part of it. Sanctions in drug court need to be progressive. Progressive in that the first time, whatever the sanction might be, the second time it needs to be greater than the first time. You run into all sorts of potential difficulties when sanctions are too low or sanctions are too high. So knowing that you're invested in a treatment program, you have to look at the sanction that accomplishes your goal by getting their attention, but not derailing all the hard work you've set out to do. If you have a client, for example, who's working and is paying for a sober living home, if you sanction them for a period of time that's too long, they're going to lose their job, they're going to not have a place to live, and as a result, you're going to destroy their ability to be able to do your program. So if you accept that they're going to be doing a program and on probation to do this, you've got to find a sanction that doesn't go too long. And I think the research says probably a max of 6 days. I use sanctions between 2 and 6 days. I use immediate jail. I use weekends. I will use some community service for some sanctions, but most uses are jail sanctions. But they need to be progressive, and you've got to be careful that you don't create a situation where you have the same sanction occurring over and over again that's causing habituation, and what they'll do is they will just come in and keep doing the same thing because they know that the max they can get, that ceiling is 2 days or 4 days, they'll continue doing it. So those sanctions have to increase, but they have to have some connection to the program you're doing and whether or not they're working, not working. You know, a kid who lives at home can take a sanction differently than someone who's working and paying for sober living. One might need immediate jail, the other one might be able to get weekends. So you have to kind of look at your party and the nature of what your sanctions are and how they progress all the way to the point where you might be putting them into a placement or a jail-based treatment program. Those are all increasing sanctions. Some of the things that we use in our county of the types of sanctions and incentives that we use in this situation, sanctions, about when a person is non-compliant with a program. I look at non-compliance 2 different ways. There's the use of drugs and there's behavioral issues. We call those proximal and distal goals. The distal goals, those things that are further away and harder to accomplish, like sobriety, we kind of treat them with less severe sanctions than someone who has proximal goals, like getting to his program, getting to his group. So some of the sanctions that we use really depend on the type of behavior that the person was involved in, whether it's a positive UA or whether it's some behaviorally by not showing up to group, not doing their community service, not turning in their NAs, things like that. Those are behavioral problems and get dealt with a little bit differently. One of the ongoing problems that drug courts deal with is people that are on appropriate prescribed medication. One of the things that we can't do is we cannot act as the doctor and tell a doctor that a person cannot be on this meds. So there are clients that have appropriate medical problems that will be testing positive for some illicit drug. Well, we have to deal with that. And you deal with that by testing that appropriate drug. You deal with that by obviously suggesting other ways and other things that a person might be able to take other than the one that the doctor prescribed. Oftentimes, our clients are not telling the doctors that they are an addict and they're getting medicine that fits within their addiction. So they need to be honest with their doctor and let them know that they are in recovery, and they preferably not have something that's a narcotic, and we can work on those, but that is a problem. We are not allowed to deny person access to a drug court because they're on some other kind of medicine that may test them positive. So you have to kind of work around it. It is a little frustrating at times. You have to check your nanogram levels and check levels to make sure that they are using within the prescribed way that the medicine is given out. And you count pills might be another thing we end up doing. But this is one of those things that we have to look at, and we have to consider that. They have to be medically approved, and again, we want to try and look for other options that we can have them look at so we don't have to deal with that problem. Therapeutic adjustments. When we deal with sanctions, we're dealing with two types of sanctions. We're dealing with a sanction that deals with behavior, and we're dealing with a sanction that deals with your recovery and your addiction. One of the things that we do when we sanction people is you might put them in for a weekend, you might give them community service, you might have them do something that's more the behavioral side, but then you make a therapeutic adjustment to the recovery program. Do you add more NAs? Do you add individual therapy sessions? Do you add a few more groups? Do you send them to an anger management class? Do you send them to outside recovery programs? You have to increase the therapeutic side of their treatment in addition to dealing with the behavioral problems that you sanction them for. So you're always looking at ways to adjust or increase the nature of what they're doing in their program to respond to their positive UA or their lack of cooperation with the program. And this is something that's an ongoing adjustment, because as the people progress through the program, depending on where they are in their phases, those adjustments need to be made depending on that individual and that individual's needs. And these are somewhat tailored to the individual and where they're at in their recovery when they do violate. In adult drug court, I use about a 3-to-1 ratio of positive to negative. Juveniles, I think, is something like 6-to-1. Adults need positive information. They need to see that when they're showing up and doing something that they feel like they're doing the right thing, because they don't really know. For every person that might get sanctioned, you have to also deal with all the positive things that follow with that. So a person who may test positive comes to court, and I may say something about their positive UA, but I'm going to build up the fact that they continued to show up to group, that they were honest about their use and dealt with their use in a very productive way, that they're programming and processing their group in with their counselor, and that, for me, they showed up to court. They walked through my courtroom doors knowing that they're going to go to jail. That's a big one for me, too. So it's very important that we incentivize, as it were, to make sure that we prop them up for all the good behavior they do so they don't see everything as being negative, because that's typically the way that they get it from all other courts that they've been involved in, is it's kind of a negative thing and a negative thing. So you need to prop them up. You need to give them praise for showing up, praise for handling it, praise for not running like they would have done in the past. So it's actually more important that I think that you praise and build up than dealing with the sanction, because they expect the sanction. They're not expecting all the positive things that you say about them for showing up in court. We also reward good behavior with other kinds of incentives. When you phase from one phase to another, you might get coins, you might get certificates, you might get gift cards, you might get your card in what we call a fishbowl, where you have a drawing for later. So we use not only verbal incentive or verbal praise, but we use physical incentives too. We give people script money. They might have less court appearances. They might be able to take and go on an outing or something. So in addition to all of the normal good things we do in positive reinforcement, we're also coming up with little tangible things that a person can have to help them feel like they're doing good. People like to touch things and feel things. So I use coins for phasing. I use coins for different things, and they touch them and feel them, and something for them to have, and it reminds them of all the good work they do. I use T-shirts so that they can look at themselves in the mirror and with that T-shirt on and say, wow, I remember that. I'm doing good. And so anything that you can come up with, and you can look at almost anything that works as an incentive if it's something that they don't have and otherwise probably wouldn't have access to. These are good incentives for people to keep doing good work and keep having them come back. We give things like bus passes and other kinds of incentives that will help people, get around. We get money for glasses. We have script to get you to go to a dentist, things like that, those things that you may not be able to get to do. Those are other things that we use as incentives. Most drug courts are in phases. Our drug court is in 4 phases, the last phase being the aftercare component. Each client needs to participate and progress through those phases. Each phase has certain requirements that they must accomplish. A certain amount of Narcotics Anonymous or AA meetings or self-help meetings they need to go to, the amount of groups they need to attend to. In my court, they need to be doing community service, have a job, or going to school. In phase 1, it's 20 hours a week. So there are whatever your drug court sets out as the guidelines for their phasing requirements. The clients then work within that phase to accomplish those goals, and when they do, we promote them in open court. I have them usually write something out, and I have them read it. I will ask them questions about some of the stuff that they write. I give them a certificate, and I give them a coin, and I praise them for all the hard work they do. Within that promotion period, each phase has different things that they need to accomplish. Of course, sobriety is clearly one of those, but they need to accomplish different things in each phase as they progress through. They also come to court a little bit less. That's part of the promoting process. Phase 1 is every week. Phase 2 is every 2. Phase 3, and Phase 4, every 4, and that's subject to each drug court a little bit different. That promotion process then is part of that, because in addition to being able to advance into phase 2, now they don't have to come back so often. And it makes it easy now, maybe easier to get a job or to start going to school. And when they get into phase 3, they're back every 3 weeks. And again, it gives them more freedom. It puts more on them and puts more responsibility on them, but it's the way that we get them to progress through each one of these phases so they can get to the end and complete it. Obviously, depending on what phase you're in, if you have a relapse or you have behavioral problems, your sanctions are going to be greater depending on what phase you've promoted to. So people in phase 1 get a different sanction than someone in phase 3 or 4 doing the same behavior. They've been there longer. We expect more from them. So part of that phase promotion is the fact that you'll have to deal with consequences that are of a greater magnitude than someone that might be in phase 1. Jail sanctions, or sanctions in general. Again, back to this part of sanctions. If you've accepted that you're going to work with a drug court client and they're going to be on probation and you're going to allow them to live out in society, you have to accept that sometimes your sanctions may derail that. And unless you're going to be prepared to put them in a placement or a jail-based facility or something, you have to look at the sanction that accomplishes your goal, that gets your attention, but doesn't derail all the hard work that they do. So we use jail sanctions, but I use it judiciously and I use it sparingly. I start out with a couple of days, and my worst sanction is about 6 days. I vary by way of whether I transport them back to court or whether they get released directly from the jail. One's a little bit more of a pain in the neck than the other. I use a weekend commitment, which is like a work release for those people that might lose a job if they get taken into custody for a couple of days. So my sanctions by way of jail are designed to get their attention, a little bit to make it uncomfortable and have them think through what they did, but it's not designed to derail all of the hard work we've done in a drug court setting to get them as far as they've got there. So you've got to find what that number is, and it's different with everybody, even though we're trying to be consistent. John Doe has been to jail 2 times in his entire life, and 2 days is killer for him, and Jane Doe has been to prison 15 times, and so a weekend is nothing to her. So you got to look at your clients again and see how the sanctions unfold and whether they will get the accomplished attention that you need to get, trying to be consistent with all of them, but you've got to look at the effectiveness of those sanctions to the individual that you're sanctioning. I don't like to terminate people from drug court. That is the last result. When we get to a point of termination, we failed and the clients failed. But sometimes you need to do that. Sometimes they're not making any progress in the program. Sometimes they're not meeting their phase needs, or they're not meeting any of the needs that are required of them in the program. Sometimes they become a danger or a safety problem in the community, and we have to remove them from the community. Non-compliance with probation, continual behavioral problems, continually using, these kinds of things that would probably submit a person to potentially being terminated if they're not otherwise making progress. I can tell you that generally I don't sanction someone for continuous use. If they're showing up and suiting up and making efforts and trying, I deal with the use by therapeutic adjustments, but I generally don't just terminate them just because they continue to get high. If they are not doing all the other things, well, then that's something I need to consider. But if they are showing up and making an effort but still can't seem to get over the hump, I still work on that. So for me, the ultimate termination is having to sentence somebody out to prison because they've not complied with the program. I have a particular way of handling that. I generally sentence people in such a way that they don't feel like they're getting punished for trying to go to drug court, because that was one of the problems we were facing, is people felt that if they came to drug court and didn't finish it, they would get an aggravated term and get punished for trying to get sober. So I don't do that. I may sentence them out, but I kind of do it somewhere in the middle. In California, we have a middle term that we use. And I do that so they don't create an environment where they think like they're going to get punished if they try and get clean and they don't. At least they'll show up and make an effort to try and get clean, and that's all we want is them to try, because if they don't try, it's pretty difficult to even get them in the table. These are the winners. Okay, these are the people that finish our program. What are the consequences of graduation? In California, we have a couple of things. We have obviously misdemeanors and a 1203.4 mechanism. I use both. I reduce felonies to misdemeanors, and then I do a 1203.4 dismissal mechanism. It gets it off their record. It cleans their record up so that it allows them to go get employment, allows them to do things that they could not do with their record before. In addition, I try and clean up old cases that they've successfully completed probation but may not have actually petitioned to have them done. When they complete their program, they get their cases dismissed. They again receive diplomas and they receive incentives. And we set them up with a packet of information for their future, of things that they can do and places they can go to seek out help in the event that they end up having another relapse. And unfortunately, some of them have that problem. But the win for all of us is when we see that person standing in front of us, 18 months or more clean and sober, and we get to dismiss their case, and they get to look at their family, or their family looks at them in a different way. That's kind of why we do this, is to see that in result when that person has completed that full 18-month program and getting that case dismissed. You'll notice by looking at this slide, there's lots of resources out there, not only in California, but lots of the entire country. We've been running drug courts for a long time, and now that we have all of our evidence-based research down where everybody can get to it, it's very easy for you to look at this information that's written down and be able to show anybody who's questioning whether or not this works or not. Unfortunately, a lot of times in what we do, if you're starting up drug courts or in the middle of it, you've got people you need to convince of the efficacy of what we're doing. And so by going to some of these resources, you'll be able to show them actual statistical proof that these programs do in fact work, that we have great results, that we reduce recidivism, and we get people's lives back on track. And unfortunately, we are, all of us that do drug court, we are advocates of it, and we are people that have to educate those of us that are around us who don't know about drug court that these things really, really work. I've been lucky doing this for 24 years now in drug courts. It's the best job in the world. I love seeing people get their lives together. It's not necessarily the easiest thing to do, but it's certainly the best job I could have ever had. And thank you guys for listening to it. I'm more than happy to answer any questions when you're done.
Thank you, Commissioner. We have 3 questions for you. The first question is, what is the ideal length of flash incarceration?
I like 2 days, personally. I use 2 days because it's effective. It kind of derails a lot of what they may have had planned. They have weekend plans or they have things on it. It's not too much, but it's enough to get their attention, and it's a pain in the neck. So I tend to use 2 and 4 days, and I use weekenders and straight time as a way to vary it a little bit, but I find that the 2 days is probably my best sanction. 4 becomes a little bit more a problem because it starts affecting their work, their school, their job, their community service, and a place to live.
Thank you. That's very helpful. Another question that relates to your policies and procedure, handbook and or manual. How frequently is that handbook updated, and what would lead you to have to update your procedure manual, policy manual?
Well, we had to update it when Prop 36 came out. We updated it when Prop 47 came out. We updated it with Prop 57. So we are updating it when the law changes. We have to update it when we have changes within our program itself, whether we have a change in a provider, change in some of the modalities that we do. So anything that's going to be changed, you're going to have to do it. And the nature of a drug court is you're always changing it. You're always trying to make it better. You're always trying to adjust it to deal with the ongoing issues that come up, so that handbook then has to be adjusted to meet the same kind of adjustments you make within the confines of your program.
And then the last question, and this question is one that relates to some of the debate and controversy around AA meetings about whether they're effective, whether they are not effective. We don't have to weigh in that, but the question I have for you, is AA part of used as part of a therapeutic adjustment? Is that part of your program?
Well, you know, I use self-help meetings a lot. I think there's a very gray area about trying to use the self-help meetings as a sanction, because then that gets into that problem of sending people off to NA or AA, and they're forced to go there. So I'm not really comfortable about using self-help meetings as a sanction. I require that they go, and if they don't go, I tend to add community service and do other things so I don't make it look like the NA is a punishment. One of the things I've noticed, I did a national NA conference last year, about 250 people, and the first question I asked was how many were here court-ordered originally, sanctioned, and about 70% of them raised their hands. And then I asked them how many were here and they're not court-ordered sanctioned, and about 70% of them still raised their hands. So the point being, even though we force them to NA and we tell them to go, they end up getting it, they end up liking it, and they end up getting involved in it, and that's why it's the essential component. My pet speech to everybody is the NAs are the hot fudge. You have ice cream and hot fudge. Don't bother me if you don't put the hot fudge on the ice cream, because without these self-help meetings, it's worthless. So I firmly believe in our self-help meetings, whether they're NA, AA, Al-Anon, CA, Celebrate Recovery, it's all the same.
Well, those are all of our questions, and I want to thank you so much for being able to provide an overview of what you do in your court, and hopefully that'll be broadly helpful to others who are listening in. I'd like to also let everyone know that our 5th webinar in the series, Standard 5, Substance Abuse Treatment, will be held on Tuesday, May 23rd, 2017. The webinar will feature the Honorable Gregory Shren and Principal Analyst Gavin O'Neill from Alameda County Superior Court. I want to thank all of you for joining us this afternoon, and we look forward to having you participate in the future. Have a good day.